What did you do to address the mold issue?
We had to replace all the hardwood floors.
So you replaced the floors, but...
Every time that she had a problem, we came and
I
fixed
understand
it.
that.
Every time she called, the next day we were there.
I get that. Did you do mold remediation? Did you remediate?
I had heaters there for days, working, taking off, moving the refrigerator, and one wall in the pantry, we had to replace the tile below the sink. That floor below the sink is tiled as well.
Right. But replacing the tile does not solve the mold problem.
I know.
So
Before we start tiling,
right,
we tear out all the part that was rotten and replace it.
Okay, I'm going to go ahead and open it up.
You said you had a plumber's report.
Yes, sir.
I'm looking through the evidence. I don't see the plumber's report. Where is the invoice?
Yes, sir.
Sorry.
It's okay.
While you're doing that, Ms. Flournoy, I'd like you to look at defendant's evidence, page 19, where you say, I want to apologize and ask your forgiveness. What led to that?
We went to the bank to get the money, and I told her that since they were overcharging me for the rent, the mildew was back. I didn't feel like I should have to give her no money because, to my recollection, we were friends, and I thought that we had came to an agreement.
Agreement for what, though?
We're going to agreement because I called her the devil, because she told me.
Okay.
I called her the devil, so I was apologizing for that because I said, it's overwhelming, let's let the housing take care of this. But she didn't want me to go to the housing because she knew it would be against the rules, and they would never let her rent a property out to another person on housing,
right,
because she knows the rules.
And by the way, you say, I want to ask for your forgiveness. I will not go to a lawyer for overpayment.
Yes, I did.
When she wrote that to you, what did you think she was talking about?
You know, Miss Flournoy first threatened me with the housing authority, then threatened me with the fair housing authority.
But threatened you for what?
I am not sure.
Fair.
I know she has a bad temper. That's all I know.
What's that?
I have the text messages of that conversation. She went to the housing authority and asked them, could she charge me for the HOA?
Got it.
I have proof right here where they say no. But you still took that $1,060
From what
from
period
me.
to what period, though?
From 2023 to 2024.
You were charging her how much? A month?
I'm sorry. I don't know that because she always gave me less money. Always.
What was she supposed to? What was the correct amount every month?
That's it. It
For the year
changed.
2023?
It was at one point 728 something.
Officer Montejano, I think the plaintiff's evidence is something we don't have up here. Let's
Yes,
get that,
I have
and then we're
all
gonna...
the stuff that you
I
guys
think
don't
we have
have
enough.
up here.
Yeah.
We think we have enough.
Yes.
So we will excuse the parties while we deliberate in this matter.
Okay.
Thank you both very much.
Ms. Flournoy, Ms. Hogue, we have deliberated and reached a unanimous verdict. And the plaintiff bears the burden of proof in court when you bring a claim. However, landlords are supposed to maintain rental registries, and I hope you will do that moving forward. Records of when rent is paid.
Yes.
Nonetheless, as we told you both, we reviewed the written evidence very carefully. And we found communications from you, Ms. Flournoy, clearly setting forth that at least for part of this period, you had been charged a very specific amount over what you should have been charged for HOA fees. And you asked if Ms. Hogue had addressed that with somebody, and she wrote no. So in a case where the burden of proof is 51%, 0.1%, that was enough. We believe that you were overcharged based on the totality of the evidence slightly. Perhaps not in bad faith. We're not saying you did it intentionally or in bad faith, but we believe there was a certain amount of overpayment. We're limited to what we have some evidence of. So we found the overpayment to be about $2,200. With respect to the security deposit, the mold wasn't remediated. There was no mold remediation work done by experts. So I think to hold Ms. Flournoy responsible for the mold damage, it's inappropriate. However, there were a number of items we think you should be charged for. The plumbing fixes that needed to happen separate from the mold. So we came up from the evidence with about $800 that you're due back from your security deposit. And we tack that on to the overpayment of rent. So with those in mind, the verdict of the court is to grant the plaintiff's claim in the amount of $3,000. And because Ms. Flournoy is not responsible for the mold damage, the defendant's counterclaim is dismissed. And we wish you both the best.